Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, coming off the heels of the big win 1 week ago in Duncan V Banta, we knew the state of California would crap its pants. We knew the state of California would appeal, and we knew we'd probably be in for a long haul. But there's been some other developments now from the Ninth Circuit, which are disturbing, to say the least. They're a little bit shocking, and they're actually a little bit infuriating. So I'm going to warn all of you right now, this might be a video that you're all going to get a little ticked off on. So whether you need to go do some breathing exercises, some yoga, maybe just pour yourself 3 fingers of bourbon before you start up this video again, do whatever you need, because right now we need to talk about infuriating developments in the Ninth Circuit on magazine bans. Okay, so we're talking about Duncan V Banta again. We're not going to really get into the actual ruling, but we're going to talk about what's happening and how the state of California is crapping its pants. And the Ninth Circuit is not doing you, the lawful and responsible gun owners nationwide, any favors right now. Now, after Judge Benitez ruled, and let's compare this to what happened on the last go-around, because let us all remember that Duncan V Banta is not a new case. This case was argued years ago, okay? And as we know, the first go-around, Judge Benitez found the law to be unconstitutional. It was then appealed by California. It went to the Ninth Circuit. It went to a 3-judge panel. That 3-judge panel also found California's magazine ban to be unconstitutional. So at this point, Duncan is 2 for 2. But then California appeals again to a full en banc panel of the Ninth Circuit, who then reverses the lower court's decisions, finding that California's magazine ban is perfectly okay. That case then goes up to the United States Supreme Court, is GVR'd back down after Bruin, and away we go. Now, on this case, as we know, Judge Benitez has ruled yet again that magazine bans in California are still, shockingly, unconstitutional. The state of California has appealed it again, and Judge Benitez knew they were going to be appealing it. That's why he built in a stay on this for them to do that, okay? However, and this is the thing that has a lot of legal scholars really freaking out about this, rather than this being accepted by the Ninth Circuit and being assigned to a 3-judge panel, instead, the entire Ninth Circuit has skipped that one step, something it never does, and has now accepted this for review by the entire en banc panel of the Ninth Circuit. So we're going to skip over a step in order to make sure that we get to the full panel, which interestingly the last time struck Judge Benitez down. Can you see where this is likely going? Now, Chief Justice Maguire signed the order of the court, which states as follows: in this circuit, matters arising after remand are directed to an en banc court, which will decide whether to keep the case or refer it to the 3-judge panel. General Order 6.4, moreover, provides that emergency motions and potential comeback cases are directed to the previous panel that had heard the case, which, in this case, is the en banc court. So, the Chief Justice of the Ninth Circuit now is saying that no, this goes immediately to the full panel, and we know how that panel is likely to rule. The Chief Justice also ruled the motion for temporary administrative stay is granted. The injunction issued by the district court is stayed through October 10th, 2023. The stay does not apply to the district court's order enjoining section 32310C and D for large capacity magazines that were lawfully acquired before the district court's order. So, all of this is put on pause now so that the Ninth Circuit can get the full panel together to hear Duncan V Banta. Now, again, we could all see where this is going. But what is more irregular is that the en banc panel's extreme actions here to actually skip this crucial step and accept review of this, knowing full good and well that they intend on reversing Judge Benitez, has been met with some very, very strongly worded dissents from other members of the Ninth Circuit. And while it is not uncommon to see judges voice their dissent when a court decides to take a procedural action, the language here is something that we should all pay attention to. Justice Bumate, writing in dissent, stated as follows: For over a decade, our court has improperly interest balanced our way around the Second Amendment. The Supreme Court has had enough of it. In Bruin, the Supreme Court made clear that the Second Amendment must no longer be deemed a disfavored right. That justice also went on to point out, with this clear direction from the Supreme Court, you might think that our court would return to regular order and handle the Second Amendment case like all others before our court. And in the normal course, emergency motions would be handled by a 3-judge panel. But not here. Because this is a Second Amendment case, we now take the unprecedented step of taking an emergency motion as an en banc panel in the first instance. While our rules may leave room for such an unusual step, discretion and wisdom counsel against it. Indeed, to my knowledge, no en banc panel of this court has ever handled an emergency administrative stay motion as an initial matter, and the majority cites no precedent otherwise. So I am left wondering why we rush to do something so unorthodox. And Justice, I think we can all read between the lines what is being done here and why they are rushing to do this. Now, Justice Van Dyke also authored a dissent and was much more vociferous in his opposition to it. As the judge put it, apparently, even summary reversal by the Supreme Court has not tempered the majority's zeal to grab this case as a comeback, stay the district court's decision, and make sure they, not the original 3-judge panel, get to decide the emergency motion and ultimately the eventual merits question in favor of the government. I think it is clear enough to everyone that a majority of this en banc panel will relinquish control of this case only when it is pried from its cold, dead fingers. And I think it is clear enough to everyone why. The judge then went on a little bit of a tangent about what the court calls the abortion distortion. That is an issue which is so emotionally charged that the court has a tendency to take procedural shortcuts to try to get to their desired results. And that same phenomena apparently takes place in the Ninth Circuit when it comes to your inalienable Second Amendment rights. As the good judge pointed out, cases involving the Second Amendment in our circuit have unfortunately suffered from a like phenomena. And just as we should no longer distort our rules in abortion cases, we should no longer apply different rules to different constitutional rights. We should not give Second Amendment cases special treatment. The judge went on to further state, but the current irregularities highlighted by Judge Benitez's dissent are not the only way this case continues to demonstrate our court's enduring bellicosity towards the Second Amendment. The irregularities in this case run much deeper, indeed all the way back to when this case was first called en banc. This en banc panel was born in illegitimacy, and this case should never have been taken en banc in the first place. Bellicosity, what an amazing word. Okay, for those of you who don't know what that means, that is the manner in acting in an aggressive fashion as if you are preparing for war. Now, the judge also pointed out a lot about this is deeply troubling. First and foremost, we have rules for a reason. We operate under them every day. They should apply equally and consistently unless and until we change those rules in the normal course. There is no exception for cases that some of the judges on our court really care about. That would be capricious and erode external and internal confidence in our court. If we lack the temerity to codify a Second Amendment exception in our en banc rules, we should have refrained from employing it behind the double veil of internal court matters in which only some members of the court participated. And finally, the court points out, in sum, not only is our court treating this case special now, but the process that brought this case en banc in the first place was illegitimate from the start. This demonstrates and perpetuates this court's anti-Second Amendment posture, rewards the weaponization of one-sided collegiality, and damages the internal and external integrity of the court. How are we to uphold the rule of law and reassure the public we are doing so when we disregard our own rules and make questionable decisions like this behind closed doors? The story of the Second Amendment in this court has been a consistent tale of our court versus the Supreme Court and the Constitution. That tale continues today and will continue as long as a number of my colleagues retain the discretion to twist the law and procedure to reach their desired conclusion. As uncomfortable as it is to keep pointing that out, it is important the public keeps being reminded of that fact. And kudos to Judge Van Dyke for having the kuyas and the tenacity to write that dead on. So, on Duncan V Banta, the Ninth Circuit has accepted review en banc. It's going to skip the 3-judge panel. This is highly irregular. This does not bode well. What do I believe is going to happen? What do you think is going to happen? The Ninth Circuit is going to flip this again. They're going to come up with some incredibly intellectually dishonest ruling. They're going to ignore the clear constitutional mandates. In this case, ultimately is going to end up likely before the highest court in the land. We will keep you posted on this. Obviously, there will be a lot more developments. This battle is a long way from over. The case, once again, obviously, is Duncan V Banta. We'll link that up down below so that you can see everything that's going on and geek out on it on your own. In the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. In the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.